So there are a couple of main things that have happened in the legislative side in Australia in the last couple of years. The first one was in 2015. The Australian Parliament passed new legislation requiring the mandatory retention of certain metadata by carriers and carrier service providers. So we're talking about telecommunications companies and ISPs are going to have to retain certain types of metadata in relation to telephone calls and other types of communications such as emails to identify when those communications took place, to whom they took place, and the location that the communications took place. The purpose of that was so that that information can be accessible by law enforcement, primarily the Australian Federal Police, the State Police, and other law enforcement agencies. The second main development which is taking place right now is that new legislation has been passed, an amendment to the Privacy Act in Australia, which requires the mandatory notification to victims of data security incidents. So these are called eligible data breaches. If one of those types of breaches occurs, then there's an obligation on the corporations that have lost access to the data to actually report that to the Privacy Commissioner and also to the data subjects themselves. In both cases, there are going to be increased compliance costs. So, for example, in the retention of information, the metadata retention, there's a considerable cost in actually making sure that you have the systems available to retain that information. And similarly, in relation to the obligation to report data breaches, going along with that obligation is an obligation to conduct proper investigations, where it's in circumstances where it's uncertain as to whether or not a breach has actually taken place. So corporations that hold data actually have to spend a bit of time and a bit of money and also have to understand how to conduct those sorts of investigations. There's also, as with any new legislation, there's also a bit of uncertainty as to how certain of the provisions are actually going to be interpreted and enforced by the courts. There's a potential for disputes to emerge. Look, frankly, it's all about planning. Businesses have to have a plan not only for responding to cybersecurity incidents, but also in relation to plan how they're going to prevent these incidents occurring in the first place. So a large number of cybersecurity incidents occur simply because of old operating systems that haven't been patched. Right? Patching systems, it's the number one way to stop yourself being a victim of a data breach. And to actually have a plan for responding to an incident, you need to understand how your communications protocol is going to work. The number one thing is having a plan, and then the second thing after that is from time to time testing it. On the horizon, as I mentioned, is we do have these two significant pieces of legislation that are literally just starting and about to start next year. We really don't know how these things are going to be interpreted in practice, what disputes they're going to produce. We also don't know whether or not there are going to be sufficient resources thrown at these issues by people in private business and also by the government in actually administering it. So the thing that we're really looking out for in Australia is we have this brand new legislation, we have these brand new obligations. How's it actually going to work out? And we're going to start to find out between now and in the next couple of years, see how that works out.